Indian Evidence Act 1872, plain barracks reading. So I'm going to read just a barrack. So let's begin. Preamble. Whereas it is expedient to consolidate, define, and amend the law of evidence, it is hereby enacted as follows. The Indian Evidence Act is divided into, I think, 11 parts. And first of all, we need to know the structure of the Indian Evidence Act, structure of this act. So here we can see it has total 167 sections, one schedule that was already repealed, so at present there is no schedule in this act, and 11 chapters. Okay, so I think it has 3 parts. It is divided into parts also. So first of all, part 3, yes, it has 3 parts. So first of all, we're going to read part 1, that is chapter, of course, 1 and 1. Okay, 1 and 2, I think. Let's see here. First of all, section 1. Section 1 is short title, that means the title of the act, which is, of course, Indian Evidence Act 1872. Extent India except Jammu and Kashmir, and all judicial proceedings, including civil and criminal, except affidavits or arbitration. Then commencement of act, I think it is September. I have to see the barrack. Okay, section 2 is already repealed. So section 3 provides the definitions of this act, which includes, among all these definitions, includes court, fact, relevant, fact in issue, document, evidence, proved, disproved, not proved, India. So how many definitions are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 definitions. Okay, this is interpretation clause. After this, section 4 provides the definition of may presume, shall presume, and conclusive proof. Then chapter 2, which provides of the relevancy of facts. So first of all, today in this video I'm going to read the interpretation clause. Okay, and of course chapter 1, that is preliminary. So let's begin. The title of the act is the Indian Evidence Act 1872. This is act number 1 of 1872. That means in the year of 1872, this is the first act which is enacted in that particular year, this 1872. So that's why it is act number 1 of 1872. The date of its enactment is 15th March 1872. But the date of its commencement is here under section 1, commencement of act, and it shall commence into force on the first day of September 1872. So commencement is first day of September, that means September 1, 1872. The year is same. Then section 2 is of course already repealed. Then section 3 we find the interpretation clause. But before going through this, we have to read the extent. That is also important. It extends to the whole of India except the state of Jammu and Kashmir. It is same as other acts also, and applies to all judicial proceedings in or before any court. Of course, it is judicial proceedings. Judicial proceedings includes both civil and criminal proceedings. Okay, this act, the Evidence Act, is applicable to both civil and criminal proceedings on in or before any court. Judicial proceedings, that's why in or before any court, including court martials, and this includes court martial also, other than court martial, this that. Okay, other than this, but not to affidavits. This is not applicable to what? Affidavits presented to any court or officer, not to proceedings before an arbitrator. So arbitrator, proceedings before an arbitrator, that is of course arbitration proceedings, are excluded. This Evidence Act is not applicable to arbitration proceeding, because the proceedings before an arbitrator is the proceedings which are mostly of quasi-judicial nature, QUSIJUDICIAL, quasi-judicial nature. These are not judicial proceedings. That means these are not proceedings before a court. Okay. Then commencement, of course, 1st September 1872. Sections 2 repealed. Section 3 interpretation clause. So we are mainly here concerned with section 3. That is very important. First of all, you have to know the definitions of certain terms. Okay, terms and expressions. So interpretation clause. In this act, the following words and expressions are used in the following sense unless a contrary intention appears from the context. So exceptions to apart, these following expressions are used in the following sense. Okay. Number one, court. Court includes, the word court is under the quotation of course, includes all judges and magistrates. So court, what is the meaning of the word or expression court under the Indian Evidence Act? This expression includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Okay, this thing court does not include arbitrators legally authorized to take. Those arbitrators of course who are legally authorized to take evidence, these are not included. An arbitration or arbitral tribunal is not a court in this sense. But court includes all judges and magistrates and all persons. It may be civil court, criminal court, anything, because the act is applicable to all kind, both civil and criminal matters. Then comes fact. Fact means it includes number one, anything, state of thing, or relations of things capable of being perceived by senses. So in this definition fact, there are two subsections are there, subsection 1 and subsection 2. Okay, fact means it includes number one, anything, state of thing, or relation of things capable of being perceived by the senses. Okay, it is a thing or anything or state of things. It may be anything or it may be certain state of things or relation of things capable of being perceived by the senses. Okay, two, any mental condition of which any person is conscious. It may be some kind of mental conditions of which any person may be of conscious. Okay, so to understand this expression fact, we have to go through the illustrations given here. A, that there are certain objects arranged in certain order in a certain place is fact. There are certain objects, okay, arranged in a certain order in a certain place is a fact. Okay, then B, that a man heard or saw something is a fact. Okay, C, that a man said certain words is a fact. Said certain word. Okay, for example, here I am making this video. Okay, it is a fact. D, that a man holds a certain opinion, has a certain intentions, acts in good faith or fraudulently, or uses a particular word in a particular sense, or was at a specific time conscious of a particular sensation is a fact. For example, here I am making this video. I am teaching you what is the meaning of fact. I am holding certain opinions. I have certain intentions. The intention may be good or may be fraudulent, or uses a particular word. For example, I am using certain particular words in a particular sense, or is or was of a at a specified time. The time is here 11:27, conscious of a particular sensation. Okay, I'm conscious of something is a fact. Okay. E, that a man has a certain reputation is a fact. Okay, I'm a LLB student, so it's a fact. Okay, my name is XXYZ, it's a fact. That's quite interesting. Then after understanding the word fact, anything, state of thing. Okay, it may be anything, it may be certain state of things, state. Okay, state of things or relation of things or relation of those things. Anything, state of things or relation of things capable of being perceived by the senses. Senses means we can perceive it through our senses. Okay, we can perceive, we can be conscious of it. 2, any mental conditions of which any person is conscious. So I already said this is because it is capable of perceived by the senses, so we can be conscious of it, we can perceive it. It may be a mental condition as well which of which any person is conscious. So illustrations gives the gives the idea about facts. Because I am making this video is a fact. My name is XYZ, it is a fact. I am a LLB honors student, this is also a fact. So these are things. So it may be a particular specified a specified time of conscious of a particular sensation. Okay, so after this, what is the meaning of the word relevant? So we have learned the meaning of the word court, that includes all judges and magistrates, before all judges and magistrates, or any person, but does not include an arbitrator. Okay, let's say it again, let's revise it. Arbitrators, except arbitrators legally authorized to take evidence. After this, we learn the meaning of the expression fact. Okay, so we have to learn after this relevant. What is the meaning of the word relevant in general sense? Relevant, there is something which can one fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of fact. Okay, this act provides the provisions of relevancy of fact, which you will read in, I think, chapter 2 of the relevancy of fact. Okay, so here the definition is, see here, one fact is said to be relevant to another. So there may be two facts, fact 1 and fact 2. Fact 1 may be said to be related to fact 2 or connected to fact 2 or relevant to fact 2 when fact 1 is connected with fact 2 in any of the ways referred to in the provisions of fact. There may be some connections, okay, relating to the relevancy of fact, which is provided under the provisions of this act. Relevant. One fact is said to be relevant to another when one is connected with the other in any of the ways. The ways are referred in chapter 2, referred to the provisions of this act, of course, chapter 2, relating to the relevancy of facts. Okay, the word relevant, the term expression relevant, relates to the fact. The fact, there is fact, it's not enough. The fact must be relevant fact. Only the relevant facts can be taken into consideration in this while deciding certain issues. Okay, fact in issue. The expression fact in issue means and includes fact in issue. Okay, this name is disputed point of view. I think any fact from which either by itself or in connections with other facts the existence, non-existence, nature, extent of any right, liability, or disability asserted or denied in any suit or proceedings necessarily follows. Explanations. Whenever under the provision of the law for a time being enforced relating to civil procedure, any court records an issue of fact, the fact is asserted or denied in the answers to such issue. Issue is a fact in issue. Illustrations. Is accused of the murders will be okay. So that's interesting. Facts and issue. This is quite interesting. Okay, the expression fact and issue means and includes any fact from which either by itself or in connection with other facts, any fact. Okay, there must be a fact from which either by itself or in connection with other facts, either by that fact itself or in connection with other facts, the existence, non-existence, existence. Okay, existence means something which exists, non-existence, something which does not exist. Nature or extent of any right. Nature, what is the nature of that right? An extent, in what extent it extends. Okay, extent of any right. It may be right of any right, liability or disability. Right, I have certain right. Liability, I am liable to certain things. Disability is absence of immunity. Okay, disability. Asserted or denied, it may be asserted means claimed or denied, it is denied, defended, there is no claim. In any suit, of course there must be some suit or proceedings or court's proceeding, maybe civil or criminal, necessarily follows. So what is this? Any fact from which either by itself or in connection with other facts, there must be one fact or any fact from which either by itself, either by that fact or in connection to other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied. It may be existence of any rights or liability or disability is asserted or denied. Non-existence of any rights, liability or disability denied. Nature and extent of any rights, liability or disability asserted or denied in any suit or proceeding necessarily follows. Okay, That's interesting, and the wordings are really nice. Any fact from which, either by itself or in connection with other facts, the existence, non-existence, something which exists, something which does not exist, something, what is this something? This something may be rights, liability, disability, which exists or which does not exist. What is its nature if it exists? What are its extents? It may be asserted by some person, it may be denied by some persons, okay? Or where this can be asserted or denied, this can be asserted or denied in any suit or any proceedings. It may be civil proceedings, criminal proceedings necessarily follows. Explanation: whenever under the provision of the law for the time being enforced, whenever under the provision of the law for the time being enforced means the law which exists at that time, to civil procedure or civil procedure, any court records an issue, a fact, the facts to be asserted or denied in the answers to such issue in effect or issue. So illustration will best illustrate the points. A is accused of murder of B. So there is a person called A, another person called B. So Mr. A is accused of murder B, means it is accused that A has murdered B. Okay, at his trial, the following facts may be issued: that A caused B's death, that A intended to cause B's death, that A had received grave and sudden provocation from B, that A at the time of doing the act which causes B's death was, by reason of unsoundness of mind, incapable of knowing its nature. Okay, this may be fact that issue. That A caused B's death, that A intended to cause B's death. Okay, he caused the death, he intended to cause the death, that A had received grave and sudden provocation from B, or that A at the time of doing the act which caused B's death was, by reason of unsoundness of mind, incapable of knowing its nature. After that, we are going to read the definition of document. Document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means, intended to be used or which may be used for the purpose of recording that matter. So what is the meaning of the document? So we naturally know what is the meaning of the document. Document means any matter expressed or described. It may be of any matter. Matter means many subject matter. That subject matter or that matter expressed or described. It may be expressed or it may be described upon any substance by means of letters. It may be by means of letters, figures, or marks, or by more than one of those means intended to be used. This is the means, just means of letters, figures, or marks, or by more than one of those means intended to be used or which may be used. Intended, okay, intended to be used or which may be used for the purpose of recording that matter. What is the purpose of matter, any matter which is expressed or described upon that substance? Recording. Recording is an important word. You have to remember document. Recording that matter. Document means any matter. There must be some matter. Okay. That matter must be expressed or described upon some substance. The substance may be by means of letters, figures, or marks. It may be by means of more than one of those means. Okay. Intended to be used. What is the purpose? Intentions. Purpose and intention. Intended to be used or which may be used for the purpose of recording that matters. Recording. Okay. Illustrations. A writing is a document. A writing is a document. Words printed, lithographed, or photographed are documents. A map or plan is a document. A map or a plan is a document. An inscription on a metal plate or stone is a document. A caricature is a document. These are documents, illustrations. Then comes the definition: evidence. Evidence means and includes, number one, all statements which the court permits or requires to be made before it any witnesses in relation to matter of fact under inquiry. Such statements are called oral evidence. Evidence means includes, number one, all statements. What is the meaning of the word evidence? Evidence, it may be statements. All statements means all kinds of statements which the court permits or requires. The court permits, okay, this evidence, or court requires to be made before it by witness. The court wants the witness to make this evidence, this statement, in relation to matter of fact under inquiry. Of course, this statement must be in relation to matter of fact, the matter of fact which is under inquiry before any court of law. Okay, that's why the court requires or permits. Such statements are called oral evidence. Why? Because it is given by the witness. All statements which the court permits or requires to be made before it by witnesses in relation to the matter of under inquiry. Such statements are called oral statements. 2. All documents including electronic records, all documents. The documents may be, of course, papers, something printed, or electronic records produced for the inspections of the court. Why these documents are produced? These documents which may be which are, of course, includes electronic records, which maybe can be produced before court. For what purpose? This can be produced for inspections. Inspections means for juries. Okay. Such documents are called documentary evidence. So there may be two kinds of evidence. One is oral and another is documentary evidence. Oral evidence is the evidence which is oral evidence is all statements which the court permits or requires to be made before it by witnesses. Oral evidence is made by the witnesses. These are all evidence which is made before the court, and the court which permits or requires to be made before it. In relation to matter, and these statements are made by this statement which is made by the witness are in relation to matter of fact. There must be some fact under inquiry, and the matter of fact is under inquiry before the court. This kind of evidence are called oral evidence. And what is the meaning of documentary evidence? To all documents, which includes, of course, electronic records as well, which is produced before the court for inspections. And such documents are called documentary evidence. Okay. After this, we are going to read the term proved. A fact is said to be proved when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a certain made out. Okay, so now I'm going to read the definition of proved. Proved, the word is under the quotation, of course. A fact is said to be proved when, after considering the matter before it, the court either believes it to exist or considers its existence. The court may have to believe it that it exists or considers its existence so probable that a pradentment, okay, the test is the pradentment ought, under the circumstances of a particular case, to act upon the suppositions of that it exists. Okay, pradentment means unbiased, something which is reasonably exist. A fact is said to be proved when, after considering the matter before it. Of course, a fact cannot be proved without considering the matter. The matter must be considered, and the matter must be considered before the court. And the court, of course, the court is here, plays the key role. The court either believes it to exist, okay, and it considers its existence so probable that a pradentment ought, under the circumstances of the particular case, to act upon the suppositions that it exists. Then after this, I'm going to read the definitions of disproved. Proved means the court considers it that it exists. Okay, it exists. Disproved means, of course, the court considers it exists after considering all the circumstances, all the evidence given before it. And the test of such consideration is the considerations of a pradentment, means the reasonable considerations. Disproved. A fact is said to be disproved when, after considering the matter before it, the court either believes that it does not exist or considers it's not existent. Of course, it's the same thing, but only differences of the wordings is that the court either believes that it does not. The does not word is only the difference here. Does not exist or considers it's not existent so probable that a pradentment ought, under the circumstances of a particular case, to act upon the suppositions that it does not exist. The wordings are almost same. Okay. Then not proved. Now here, proved, disproved, and not proved. These are technical words, I mean, used in this act. Not proved. A fact is said not to be proved when it is neither proved nor disproved. There's the interesting thing. This is the interesting thing, and it is very twisted. For example, proved, disproved, and not proved. Not proved does not mean disproved. It means what? Whether when it is neither proved nor disproved. When it cannot be proved, okay, beyond all reasonable doubts. When it cannot be even disproved either. The court cannot say that it exists. The court cannot even say that it does not exist. That's why it is said to be not proved. This terminology here you can see: proved, disproved, and not proved, and this is interesting here, and here you cannot make any mistake. Okay, not proved does not mean disproved. It means court neither proved nor disproved. A fact is said to be proved whether if said not to be proved when it is neither proved nor disproved. Important. Okay. After this, India. Okay, definition of India. India means the territory of India excluding the state of Jammu and Kashmir. The expression certifying authority, electronic signature certificate, electronic form, electronic record, information, secure electronic record, secure digital signature and subscribe. Birds shall have the same meaning respectively assigned to them in the Information Technology Act 2021 of 2000. So definitions of other things, for example, certifying authority, electronic signature certificate, all these things we have to read the Act of Information, definitions of Information Technology Act 2021 of 2000. Only then we can get these definitions. Then comes section 4. Section 4 provides 3 expressions, that is may presume, shall presume, and conclusive proof. Don't make any mistake here. Section 3 provides certain definitions, expressions, but section 4 only provides the definitions of may presume, shall presume, and conclusive proof. Okay, do not mix those. And it is chapter 1, part 1. Okay, part 1 of Indian Evidence Act 1872, which was enacted in 15 March 1872. Wait, let me revise again. Which is enacted in 15 March 1872, and which commencement of this act is 1st September 1, 1872. Okay, so I'm reading here section 4. Section 3 has already finished. Section 3 is, the title of the section 3 is Interpretation Clause. Okay, which provides the definitions. We have already read those here. Now we're going to read sections 4, which provides what? May presume, shall presume, and conclusive proof. May presume. Whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof of it. There are differences between these things, may presume and shall presume. Shall presume means whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved unless until it is disproved. Whenever it is from may presume, whenever it is provided by this act that the court may presume a fact, it may either regard such fact as proved unless and until it is disproved, or may call for proof. Shall presume. Whenever it is directed by this act that the court shall presume a fact, it shall regard such fact as proved. Okay, after this conclusive proof is different from those may presume, shall presume. Whenever one fact is declared by this act to be conclusive proof of another, conclusive, you know the general meaning of the word conclusion, or what is conclusive. The court shall on proof of the one fact regard the other as proved, and shall not allow evidence to be given for the purpose of disproving it. Okay, after reading the definition and interpretation clause, it's already 28 minutes. I have continuously read, so I'm tired. So I'm going to end this here. If you like my videos, please subscribe, comment below. And it's just general reading of the direct. It's important to read the words directly from the point of view of judicial service exam. I have made this video in English, and I don't think so whatever. So thanks for watching. I'm tired. Goodbye.